Good evening, everyone, and thank you for joining me this evening. Wherever you are joining from, I appreciate you. Thank you for choosing to spend this time with me on Your Family Lawyer. And I hope that at the end of the day, would have had an amazing time together. This would have been fun for everyone. It would have been a great learning curve. Anyways, my name is Earl and I'm all right. I'm a lawyer and I'm also a counselor and a therapist. This is Your Family Lawyer, and everything we do here is to see how we can enlighten us, educate us, and make us understand more properly what family law is all about, what you need to understand about family law here in Nigeria. Remember what I usually say, and I'm saying this again, that this is not legal advice. In case you need legal advice regarding any legal matter that you're having right now, consult with a lawyer, because the things that I share here, they are just general information. You may not want to use general information for something that is specific. I would not advise you do that. So I would not be glad if I hear that you did that. I want to consult your lawyers if you ever have any particular matter. When we decide to do Your Family Lawyer, we decide to bring in from time to time different topics, and also bring in different people here on Your Family Lawyer, because we discover that people are asking us questions. There are questions that people have, there are concerns that people have, that if you bring to my office, you come to my office as a lawyer, you contact me as a lawyer, and you ask me those questions, we will charge you consultation fees to answer those questions, to attend to you. So talk about something else we could do to see how we can meet the needs of the general public who may not want to come to our office, who may not want to talk to us directly on phone, and those who may also not have sufficient funds at that particular time to pay the consultation fees. But then, this is not legal advice, this is just general legal education, right? I'm talking to you, reaching you from the city of Ibadan, and this evening it is raining right now. If you're in Nigeria, you definitely understand that we've been experiencing lots of rain during this period, although it is technically not the rainy season, and we'll be having major flooding in some parts of the country. We're talking about Kogi. Like my father said, I was speaking to my father some days ago, and I was asking him about the flood, if he had gotten to some particular places in Edo State and how those people are faring, because I'm from Edo, although I live here in Ibadan. And he told me that everywhere the Niger passes through is already flooded right now. So our prayers to all those who are living by the banks or the shores of the river Niger, including those who are also in the Benue, because once this dam gets filled up in Cameroon, if Cameroon opens their dam to let water go, it's going to touch the Benue River. From Benue River, it's spreading to Benue State, cities like Makurdi, down to join the river Niger in Kogi. I remember in 2012 when I was there living in Benue, flooding like this happened, and it was terrible. But well, let's go straight to custody, because we are talking about custody today, the Nigerian law, how it affects you, what you need to understand, what are the things you need to pay attention to, and how custody works generally. So you don't just think that, oh, I'm the father, I'm supposed to be getting this, I'm the mother, this everybody's supposed to be doing my bidding, I am the grandma, I am this, I am that. No, there's the way things work, and that's what I want you to understand today. When it comes to custody, you should understand that custody is a lot different from divorce, right? So when we're talking about divorce, we are talking about irreconcilable differences. We are talking about the fact that the marriage has broken down irretrievably. The two people who are the partners, who are the spouses in that marriage, no longer want to continue, or even if one person wants to continue, the marriage cannot survive. The marriage cannot continue. The marriage is too sick. The marriage is too broken to continue. That's it when it comes to divorce. So when it comes to divorce, most of the time people may be antagonistic. It may be about my way, your way, what I say, what you say. One person petitions, the other person cross petitions, and everything that has to do with that. That may apply when it comes to divorce. However, when it comes to custody, there's just one simple rule, which is the overriding interest of the child. The overriding interest of the child. It is always the child that is taken into consideration. The child is the primary issue. The child is the center of attention, is the center of decision. It is not the convenience of the parents, it is not the wishes of the parents, but the focus is on the child. What favors this child, what will be beneficial to this child, and what will be the overall good for this child over the years and over the future. So you should understand this. Yes, during a divorce proceeding, during a divorce, while a divorce petition is still on the court before judgment is given, before another nicer or the pre-nicer absolute is made, custody could also be part of the relief sought in a divorce petition. However, it is not the same mindset, it is not the same attitude, it is not the same rules that are used for divorce that will be employed when it comes to custody. Because when it comes to custody, we are looking at the overriding interest of the child. However, when it comes to divorce, we are asking ourselves, has this marriage broken down irretrievably, right? Can this couple, do they have any reconcilable differences? So these are the things that usually happen. Now, for custody, there are different types of custody, right? However, let me do two general broad types: custody when the child is born out of wedlock, and custody when the child is born in wedlock, right? If the child was born out of wedlock, maybe the parents of the child were cohabiting, or perhaps they were not cohabiting, they were living apart, or something happened that people generally call love and romance. Sex happens, and at the end of the day, there's a child, there's an issue from that sexual activity, from that sexual relationship. The way that custody is addressed, the way that custody is attended to, is a lot different from if the child was a product of a marriage, right? So these are just the two broad ones. So are they married? Where's the father? Where's the mother? Right? Is there a marriage that is still existing? That's that. In fact, this to a large extent also determine which court you will go. If it's a child out of wedlock, you could always go to the magistrate court in most jurisdictions. If it's a child born in wedlock and the marriage is still existing, there's no divorce yet, and the couple have a statutory marriage, what we usually, the place to file such application will be at the High Court or the Federal High Court. So it causes a major definition to it, right? Whether the parties are married or they are not married. Well, let's go to the popular 5 types of custody that is out there. The 5 types of custody out there that you may want to know, that I want you to understand, and I want you to get. The first one is split custody, right? So split custody is where maybe physical custody of the child is given to one person exclusively, while the other person only has the responsibility of supporting the welfare of that child, right? So we could have that split custody. Are there times where that could happen? Yes, it could happen in a situation where the two people are now living far away from in different countries, or where one person is confirmed to be mentally ill or clinically ill and will not be able to physically attend to the child. So you could say, oh, this child is with this particular parent, while this other parent contributes to the welfare of the child. Another one is divided custody. So, right, divided custody is where there's a split right now. Split right now in the sense that maybe one person is taking school period and the other person is taking holiday period. or one person is taking it is just shared, right? It gets to be shared among them. We have joint custody. Joint custody is the two of us are responsible to this child. This child gets to spend this particular time with you and spend this particular time with us. The two of us are responsible to the child's welfare. It's not just that the child is with you, I'm the one who is exclusively responsible for the child's welfare. We have temporary custody. That is very common when the child, if you go to court, you will hear issue of the marriage, issues of the marriage, issue of the marriage. But for today, let's use child. When the child of the marriage maybe is very young, of course, all kids are minor, right? Let me say this now. I've had some clients who come to the office and they want to contest custody, or they want to fight for custody, they want to seek for custody of a child who is over 18. No, it does not work like that. Once a child is an adult, and for us in Nigeria, adulthood is 18 years, you can no longer come to court to start applying for the custody of that child, because that child is an adult. The thing that ought to apply is that ordinarily by 18, the idea is that the child is supposed to be independent and living alone. So if the child is still living with any parent, the child is old enough to choose who he or she wants to live in. So if that child is more than 18 years old, you cannot say you're fighting for custody. The child has to be less than 18. 0 to 17 could make it very safe. So temporary custody happens to be where maybe this child, one of my clients had that the mom died about 10 days thereabout, or maybe 11 days after birth, and the child was temporarily given to the grandparents, the maternal grandparents, with the direction that by the time the child was 5 years old, 6 years old, and if the father had remarried, would come back and request for the custody, for review, to get custody of the particular child. So we have temporary arrangements. We have situations where the child is with a particular parent for primary school, and the child moves to the next parent for secondary school, right? So there are these different arrangements and the rest. Then we have third-party custody. For third-party custody, I had one this year, and that was where it was the aunt that was with the child, and the aunt wanted custody of the child because the father of the child was not mentally fit to handle the child, right? So custody had to go to the aunt. Another one was about 2 years ago, thereabout, where a grandmom contacted our office and said her daughter and her husband, they are always fighting. Their fights and their quarrels are always seriously violent. There are times the police have had to come in and the rest. And that she wanted to apply for custody of the child, to get the child so that the child lives with her, right? So there are situations like that where a third person may come to ask for custody. It could be as a result of the death of one of the parents of the child, or it could be as a result of the mental, emotional, or character incapacity, inability of the particular parents to attend to the child. So it all depends. So you cannot, I have heard many times of people wanting exclusive custody of a child, like 100% of percent custody of that child. They don't want the father or they don't want the mother to be in the life of that child. They don't even want your financial contributions. They don't want this and that. You see, people get to carry their fights, their personal romantic and emotional fights, and try to extend it to the children and try to extend it to the kids. The law does not agree with that. The law does not support that. The law always considers the overriding interest of the child. The overriding interest of the child is a major thing, is the most important thing. So we usually tell people, if you are coming to custody, the attitude you should have is the overriding interest of the child. Because the moment the court notices, the judge notices, or the magistrate in particular situation notices that you are just trying to be selfish, you're trying to pay back your spouse or your ex, or you're trying to use this child as a revenge or something, it will negatively affect you big time. It's always the overriding interest of the child, not your overriding interest. Not what is best for you, not what is suitable for you, but what is best for that kid at the particular time. Okay, for every time we file custody in court, for every time whether I file custody or not, I just go to court to enjoy the proceedings, and any person can do that. Well, there's a caveat to that. There's a little term and condition to that, and that's because when it comes to family matters and that affects children, most of the time the court, in order to protect the children and for public policy and morality, would usually not want to do contentious matter that affects children in public. They will usually not want to do it in public, so they usually want to do it in their chambers, or they want to list it as the last case for the day. And many times when they list it for the last case for the day, you will always hear the judge or hear the magistrate ask everyone who is in the gallery, like, who are you? What connection, what relationship do you have to this case? Yes, every case is supposed to be heard in open, in public. However, when it affects children, it is sensitive and it is allowed to be done in private. So you may not be able to participate as an observer, as a member of the public, when it comes to most family cases, especially custody. There are things that the court consider when it comes to custody that the court will take into consideration, and it is good you have this understanding from the very beginning. Number one is the age of the child. What is the age of the child? There are some judges that we know that by default, once a child is less than 5 years old, they will usually want to give that child to the mom. Of course, if a child is still suckling, right? If a child is still suckling and the child is still in those early years of where the child needs some peculiar maternal care, which a male parent may not be able to give, the court is usually tempted, usually inclined to granting custody to the mom. But it's not the same, right? That does not mean that, because the child is less than 5 years, the child will automatically go to the mom. It does not work like that. I'm only just saying that the predisposition of the court will always be to first consider having the mom attend to this child physically, right? So the age of the child of the person matter a lot. Usually, I always tell my clients that if the child is not more than 5 years old, let's still leave the child with the mom and come back maybe 2 years time, or come back 3 years time, or come back 5 years time. However, it is the peculiar case that determines. So if the case warrants us applying for custody, even though the baby is just 3 months old, we will do it. That's why I said from the very beginning that this is not legal advice, right? Because I cannot know how peculiar your case is, what are the particular facts and ingredients of your case. So you need to speak with a lawyer to be able to give you proper advice. So we are also lawyers, right? Another thing that the court also considers is the sex of the child. The sex of the child. Generally, when it comes to adoption or when it comes to fostering, if you're a single person and you want to adopt, you have to be like 25 years older than the person you want to adopt, and not just that, you have to be of the same sex most of the time, because the courts are concerned about sexual molestation, sexual abuse, and the likes. But interestingly, as at the time of making this video, this is 2022, and we are finding sexual molestation even from same gender, right? But then the sex of the child is important to know. Okay, if the child is male, then definitely the court will be thinking like, yeah, I think the child will be able to vibe and flow more with a father than with a mom. And of course, we'll be able to have a father in his life that will play that gender role figure, gender mentor, gender coach, right? So that's also one of the things the court consider. Then again, the court will look at the psychological effect of the child. Like, if we give this child to the mom, how will it affect the child's psyche? Where does the mom live? What's her job? is she exposed to, and the rest, right? Okay, she remarried to another person. What was the record? What was the social record, the medical record, the criminal record of this person that the mom is married to? So we always look at these different things as it applies to women, it also applies to men. What is the psychological effect? Are you going to be changing him from his school? That means taking him away from his friends, taking him away from the immediate community. In fact, in Islam, one of the major concerns is, are you going to be taking him to a place where he will no longer be raised under his religion? So these are some of the things that are considered. Then if the child is about 6 years old, 7 years old, I usually prefer doing that from 9 years old or 10 years old, or best if this child is already in secondary school. Is the wishes of the child. You want to also consider the wishes of the child. Who does this child want to stay with? I remember a friend who said when the parents were going their different ways, when they were divorced and the rest, and the grandma just simply asked the child, who do you want to go with? And she, who is an adult right now in her 30s, a mother in her own right, said she wanted to go with her father. So there are times that the kids will also be asked, who do you want to live with? Who do you want to stay with? Who do you want to go with? Well, usually when this happens, the kids are asked privately, and they're usually asked privately in chambers, because the judge does not want a situation that a particular parent influences the decision of that child through some undue advantage and the rest. Some of the advantages and the rest. Okay, then another thing that is also considered is the conduct and lifestyle of the parent. What's the conduct and the lifestyle of the parent like? What's your character like? Are you somebody who is known to always borrow money, and so your creditors are always on you, coming to the house, coming to your workplace to embarrass you? Do you take alcohol? Do you keep late nights? Are you always fighting neighbors? Are you always quarreling? Do you always get into trouble? What is your medical record like? Are you always sick, always admitted? Do you always get to need to be on some particular medications? The court will also consider your general lifestyle, consider how you conduct yourself, because we are looking at the overriding interest of this child. So the court will definitely know how to do anything that will negatively affect this child's psychology, this child's well-being. And another interesting thing the court look at, which many people don't know, is that the court will also look at the situation of, if we give this child to the father, will the father allow this child to contact the mom? Will the father allow the mom to still have some contact with this child? If we give this child to the mom, will the mom cut off the father? Recently, we had a matter in the office, and all the mother of the kids wanted was access to these children, access in the sense that she wanted the ability to call them, to visit them, and to have them spend holiday with them. And the father was resisting it. Thank God that particular case has ended. The particular case, okay, not ending, because we applied for striking out for want of diligent prosecution. However, when I came to the matter, because I was not the substantive counsel initially, the matter was later transferred to me. When I came to the matter, I advised my client, who was the father, I said, this is their mother. We cannot cut her off. She has to have access. I will not go to court to fight access. That's just the truth. I will not go to court to fight access. It does not make sense to me for you to say a parent cannot call the child, a parent cannot visit the child. If you want the visit or visitation to be regulated and monitored, fine. If you want contact to be regulated and monitored, fine. But for you to say you want to cut off the person 100%, no, that is you transferring the emotional issues you have with that person, the romantic issues we have with that person to the children. These are two different things. They do not, the only connection is that the two of you are their parents. So these are it. I have had people, especially now that there's a wave in Nigeria of people wanting to relocate out of the country, who just come over and say, hey, I need custody right away. How do I get custody? And I need it very fast. Well, my answer to that question is going to be in next week's episode. Remember that we do this every Tuesday, 9 p.m. live on Facebook, And from here, we share to other platforms. So next week, Tuesday, I'm going to be talking about how to go about custody, right? How long does custody take? What does custody entail? What it is you are supposed to do for it to start, for you to be able to continue with it. By the time it ends, what are the reports you're supposed to be making to the court if the court ever order all those reports and the rest. Thank you so much for following. My name is Earl. I'm alright. I appreciate you. Drop a comment, share this with your friends, and of course, join me every Tuesday 9 p.m. here on Your Family Lawyer. I'll be so glad to attend to you. Thank you so much. Let me allow you now go to sleep while I also prepare for court tomorrow. You're all.